we the people of the United States,
in order to form a more perfect union, establish justice,
ensure domestic tranquility, provide for the common defense,
promote the general welfare, and secure the blessings of liberty to ourselves and our posterity,
do ordain and establish this Constitution for the United States of America.
The United States Congress is the branch of government that passes laws. The authority to do this is granted by Article 1 of the Constitution. The Constitution is organized into 7 articles. According to James Madison, the finish given to the style and arrangement of the Constitution fairly belongs to the pen of Mr. Morris. Madison was speaking of New York Delegate Gouverneur Morris. Article 1 defines the legislature, its powers and prohibitions, and defines relations between federal and state governments. Article 2 defines the presidency. Article 3 defines the judiciary, and Article 4 outlines the obligations of the state and federal governments. Article 5 provides the amendment procedure. Article 6 contains the supremacy clause. Article 7 defines the process to ratify the Constitution. Article 1 is the longest and most detailed article of the Constitution. It begins with a clear, straightforward grant of authority. Article 1, Section 1 states, "All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives." Article 1, Section 2, defines the House of Representatives. The House of Representatives consists of members from every state. The number of representatives for each state is determined by the national census conducted every 10 years. House members are elected for 2-year terms. House members elect the Speaker and other officers. The House has the sole power of impeachment. The following qualifications are required to serve in the House: 25 years of age, 7 years a citizen of the United States, an inhabitant of the state from which elected. Section 2 also defines who is eligible to vote to elect House members, who is counted for purposes of representation, the original number of representatives for each state, the method to fill vacancies, the office of the Speaker of the House, and the power of impeachment. Article 1, Section 3 defines the Senate. The U.S. Senate is composed of 2 senators from every state regardless of population. Each senator serves a term of 6 years. The terms of senators are staggered so that 1/3 of the Senate is elected every 2 years. The Vice President is President of the Senate, voting in the case of ties. Senators elect their other officers. The Senate has the power to determine if an officer impeached by the House should be removed from office. The Senate's advice and consent power is the authority to review and approve presidential appointments and treaties. The following qualifications are required to serve in the Senate: 30 years of age, 9 years a citizen of the United States, an inhabitant of the state from which elected. Senators were originally chosen by state legislatures. In 1913, the 17th Amendment provided for direct election of senators by popular vote of the citizens of each state. Sections 4, 5, 6, and 7, the operation of Congress. Article 1, Sections 4, 5, and 6 set forth Congress' technical operations such as meeting schedules, compensation, and record-keeping requirements. Article 1, Section 7 defines how Congress is to exercise the authority to make law. Any law regarding raising revenue for the government must originate in the House of Representatives. Thus, a law imposing taxes must start in the House of Representatives. A bill approved by both the House and Senate becomes a law when signed by the President. The President can reject a bill via a veto, but Congress may enact a law by overriding the veto with a 2/3 majority vote of both houses. Article 1, Section 8 lists the enumerated powers of Congress. These are specific powers defining the subjects about which Congress may pass laws. The ratifiers of the Constitution intended congressional power to be limited to these enumerated powers. If Congress acts outside its enumerated powers, that action is unconstitutional. The power to declare laws unconstitutional belongs to the Supreme Court. Restricting Congress to the enumerated powers is the essence of limited government, designed to protect maximum freedom. The importance of limiting government grew from the colonial experience of tyrannical, absolute power exercised by the English king and Parliament. In the 1803 case of Marbury versus Madison, the Supreme Court announced the power to declare congressional acts unconstitutional. For over 150 years, the court generally saw the Constitution as a real limit on congressional authority. In the 1942 case of Wickard versus Filburn, the Supreme Court determined that Congress could regulate a farmer who was growing wheat that was not for sale, but for the farmer's own use. With that case, the court determined that Section 8's Commerce Clause gave Congress authority over most aspects of American life. This expansive view of the Commerce Clause provides Congress the authority to legislate regarding anything affecting interstate commerce. In the modern, interconnected world, few activities do not affect interstate commerce. With Wickard versus Filburn, the Supreme Court allowed Congress to assert control over most details of American life. Article 1, Section 8. Enumerated powers are as follows: lay and collect taxes, duties, imposts, and excises. Pay the debts and provide for the common defense and general welfare of the United States. Borrow money on the credit of the United States. Regulate commerce with foreign nations, and among the several states, and with the Indian tribes. This is the Commerce Clause. Establish a uniform rule of naturalization, and uniform laws on the subject of bankruptcies throughout the United States. Coin money, regulate the value thereof, and of foreign coin, and fix the standard of weights and measures. Provide for the punishment of counterfeiting the securities and current coin of the United States. Establish post offices and post roads. Promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Constitute tribunals inferior to the Supreme Court. Define and punish piracies and felonies committed on the high seas and offenses against the law of nations. Declare war, grant letters of marque and reprisal, and make rules concerning captures on land and water. Raise and support armies, but no appropriation of money to that use shall be for a longer term than 2 years. Provide and maintain a navy. Make rules for the government and regulation of the land and naval forces. Provide for calling forth the militia to execute the laws of the Union, suppress insurrections and repel invasions. Provide for organizing, arming, and disciplining the militia. Exercise exclusive legislation in all cases whatsoever over the seat of government. Make all laws which shall be necessary and proper for carrying into execution the foregoing powers. Article 1, Section 9 of the Constitution prohibits Congress from doing the following: suspending the writ of habeas corpus, taxing the ports of one state more than the ports of another, passing bills of attainder or ex post facto laws, spending funds without passing a law allowing it to do so, granting titles of nobility. Americans view the Bill of Rights, Amendments 1 through 10, as the primary protections from tyrannical government. Article 1, Section 9 contains 2 safeguards as well, and is sometimes referred to as the Mini Bill of Rights. Habeas corpus dates to the Magna Carta in 1215, and provides a person held against his will by the government has a right to a judicial hearing. Prohibitions on bills of attainder and ex post facto laws ensure that Congress cannot single out for punishment a particular person or make conduct illegal after the fact. Article 1 sets limitations on state governments to maintain congressional authority in specific areas. State governments cannot enter into treaties, coin money, pass bills of attainder, ex post facto laws or impair contracts, pass laws imposing import taxes or duties, engage in war. Article 1 contains such detail because the founders considered Congress to be first among equals. The legislative, executive, and judicial branches of the American government are described as co-equal branches of government. The founders saw the legislature as the true source of government authority. Congress is defined in Article 1 because, as James Madison said, the Congress was to be the first branch of government. The enumerated powers of Article 1 are the primary source of congressional authority. Depending upon how one counts, there are as many as 35 powers granted throughout the Constitution. Article 1, Section 1. All legislative power is granted to the Congress. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and House of Representatives. This first sentence of the Constitution is quite simple. The power to enact laws is granted to Congress. The Congress is the Senate and House of Representatives. To interpret the Constitution, sometimes there's a need to translate 18th century words into 21st century English. Article 1, Section 1 needs no such translation. All still means all. Legislative powers still means authority to make law. Granted still means given to. The 18th century provision creating Congress and defining its power is clear to any 21st century reader taking a moment to think about it. When the Constitution is viewed as a power of attorney, with the people as the principal and the government as the agent, it means that we appointed Congress our agent to make law. Article 1, Section 1 is the essence of the Constitution, granting the power to make law to Congress. When a person creates a power of attorney for any purpose, authority is given for specific acts to a specific agent, and no one else. The Constitution's ratifiers and framers were well aware of this. They were also influenced in their thinking and Constitution creation by John Locke. For Locke, an institution granted power to make law has no authority to give that power away. The legislative power is to make laws, not legislators. John Locke's 1690 Second Treatise of Civil Government provides, "The legislative cannot transfer the power of making laws to any other hands. The power of the legislative being derived from the people by a positive voluntary grant and institution, the legislative can have no power to transfer their authority of making laws and place it in other hands." Locke's 17th century English is a bit more cumbersome, but in the end, the point is clear. The legislative power is to make laws, not legislators. The creation of the modern administrative state has ignored this principle, resulting in the delegation of lawmaking power to the alphabet soup of federal agencies. There have been various explanations for why the Congress has given away the power exclusively given to it by the Constitution's first sentence. The explanations failed to comport with the Constitution. Chief Justice John Marshall, in discussing the legislative power, distinguished between important subjects and mere details. Marshall wrote that, "A general provision may be made, and the power given to those who are to act under such general provision to fill up the details." However, neither Madison or Marshall foresaw the 20th century abdication of lawmaking by Congress. How Congress fails to make laws and instead makes legislators. Here is an example of Congress not creating laws, but creating legislators. The Communications Act directs the Federal Communications Commission to grant broadcast licenses if public convenience, interest, or necessity will be served thereby. The statute grants the FCC nearly complete discretion about an issue that is fundamental to the regulation of broadcasting. The Motor Vehicle Safety Act directs that the Secretary of Transportation shall prescribe motor vehicle safety standards. Each standard shall be practicable, meet the need for motor vehicle safety, and be stated in objective terms. This statute as well provides the agency nearly complete discretion. The FCC and Transportation Secretary have not been directed to fill in the details of enforcement. They have unconstitutionally been given the power to make law. Those who are unhappy with executive orders, whether the president is Clinton, Bush, Obama, or Trump, should understand the real problem is that Congress has given away its power to the executive. The judiciary and Congress have been complicit in congressional abdication of its legislative duties. Supreme Court Justice Neil Gorsuch has been a staunch proponent of reigning in the legislative and judicial delegations to executive agencies. Justice Brett Kavanaugh agrees with Justice Gorsuch, so there is hope that future members of Congress may be forced to actually pass laws rather than passing the buck. To understand better this issue, read The Theory of Legislative Delegation, 68 Cornell Law Review, Volume 1, page 22, 1982. The preamble contains soaring principles and objectives, but it grants the government no authority. We the people in the preamble are concepts to unify the nation, but the Constitution's Article 1, Section 1, is the first constitutional phrase with legal impact. Learn more about our Constitution, like this video, and subscribe to this channel.